Welcome back to Winning Isn't Easy. Let's talk about the relationship between a workers' comp claim and an ERISA disability insurance claim. So let's talk about some basics. Workers' compensation and ERISA disability cases can be thought of as different highways that are running parallel for a while, but at some point they actually may intersect, and there can be a heck of a collision when that happens. Let's talk about what they are and what they aren't. So first off, workers' comp benefits will be paid if you're involved in a compensable industrial accident or injury. There are different types of injuries or conditions that could be compensable. So let's explain the difference because these can be used in a long-term disability claim. What happens, for example, is if you have been involved in a obvious accident and injury, you slipped and fell or something fell on you at work, that is a compensable industrial accident or injury in under most workers' comp statutes. Now, that can also be the basis of an ERISA disability claim. You might have a situation where you have a repetitive trauma. In the context of workers' comp, repetitive trauma might be repetitive keyboarding or repetitive use of a body part that results in injury, for example, carpal tunnel. That can also be the basis of an ERISA disability claim. You also may have occupational diseases. Occupational diseases can be caused basically as a result of an exposure to something, be it chemicals or toxins. That can also give rise to a workers' compensation claim and both an ERISA disability claim. Now, workers' compensation is governed by a state law, not so with ERISA. ERISA disability benefits can be paid as a result of sickness or injury. That's the general definition, unlike in a workers' comp case where you have an accident or injury, as I've described. But in the world of ERISA, the ERISA world is governed by a federal statute, and that's called the ERISA Rules and Regulations. There's another important distinction here, and that is the type of benefits that you're eligible for. Now, in workers' compensation, you can be eligible for lost wages. That could take the form of what's called temporary total if you're totally disabled, temporary partially disabled if you are able to work in some limited capacity. And those two benefits are paid before you reach what's called maximum medical improvement. Once you've reached maximum medical improvement, benefits can be paid based on a percentage of your lost earning capacity, maybe an impairment rating, or other forms of wage loss benefits, including permanent total disability benefits. In workers' comp, you also might be eligible for vocational rehabilitation services. And obviously, you're entitled to medical treatment, so long as that compensable medical condition remains related to your accident or injury. And in the state of Florida, where I'm based, the accident and injury has to be the major contributing cause for the need of treatment. Again, in the context of short or long-term disability benefits, you are eligible for money benefits based on the amount of benefits you selected, be it 60% or 65% or maybe even 70% of your wages. And what will happen here, again, is the wages will be based on a definition of your based on your policy of your earnings. You also may be able to get what's called residual disability benefits, but again, basically it's money benefits. Under the workers' comp statute, you're entitled to these benefits by virtue of your employment. Under the short or long-term disability benefit program, you're eligible for those benefits as part of an employee benefit program. And if your employer doesn't provide that to you, then you don't get your short or long-term disability benefits. Now, there also is some other important differences that you need to understand. And that is, in the context of a workers' compensation case, most employers have purchased a workers' comp policy. Now, there are some that are self-insured and self-administered, and so they will actually pay the benefits. In the context of an ERISA disability claim, your employer may be self-funded for short-term disability and they administer it, or they will self-fund the short-term disability and hire an administrator. In the context of long-term disability, they may actually have an administrator who makes the decision as to whether the benefits are paid, and a third-party insurance company may pay those benefits. Or you may have a situation where your employer has purchased a long-term disability policy that is administered and paid by the disability carrier. So the setup is different in terms of how these cases are handled, but you need to understand that ultimately at the end of the day, you have to understand that regardless of its workers' comp, regardless of its short or long-term disability, these folks are not in the business of paying benefits. And that's important because in the context of a workers' comp case, you do have the right to have a hearing in front of a judge. And as part of the hearing, you may be able to submit your testimony or testify live at a trial. You probably have the right to take the deposition of the adjuster for the insurance company. You have the right to take the deposition of doctors or other people and present that testimony in a hearing format in front of the judge. Now, in the context of ERISA, it's completely different. When you file a claim, and if that claim is denied or terminated at any point, you'll have 180 days in which to file an appeal. The appeal is the trial of your case, and the judge can only look at what is in that carrier file or plan file at the time of the denial. There's limited discovery. You might be able to take the deposition of the claims examiner, but what you can ask can be limited. And in some jurisdictions, it's practically impossible to take the deposition of the adjuster. So the court only gets to see what's in that carrier file. And that's what leads us to the rest of our discussion. But you need to understand there is no jury trial. Most of these cases are decided on what's called a motion for summary judgment. So again, in the context of workers' comp, we litigate like crazy. I'm a workers' compensation attorney in my other life, if you will. And in the context of ERISA, we don't have trials and we don't have a lot of discovery. So that's important because if the disability carrier wants to hide the ball, then that can be a problem. And they can hide the ball in the context of of your workers' compensation file if that's material to your claim. So what's also here that's important is that you understand ultimately what's discoverable and not discoverable in the context of a ERISA disability claim. By that, I mean, you might have a situation where the comp carrier pays for a while and then ultimately decides to deny your claim. They might have had an IME. Your doctor may have said you're able to go back to work, but they terminate the benefits. You can litigate that. Ultimately, you might be able to settle the case. But let's say that you also have a ERISA disability claim, and the ERISA disability carrier pays, and then all of a sudden they say, well, we're not going to pay anymore. By the way, we know you were getting workers' comp because we have the right to offset those workers' comp benefits. And we've got some stuff that we've discovered in the course of your workers' comp case that we've used to deny your claim. So you can see that this can be crucial, and not all the records in a comp file are created equal. Some can hurt you, some can help your case. And that's what we're going to talk about in our next segment. Okay, let's take a break.